All right. Hello, everyone. I am Althea Blackford, and I hope you are enjoying this wonderful session of day 3 for Boston Caribbean Fashion Week, our lovely expo of reconstruction of fashion. This particular session here is building and protecting the brand. We have a great session here for you. We have our lovely event partner from SCORE Boston. This is Bill Hulsey. He is a collegial, ethical, and entrepreneur, attorney, and senior leader with extensive experience helping nonprofit organizations do more good by improving business practices, developing sustainable streams of revenue, and managing all aspects of their legal affairs. And he is a SCORE mentor and attorney with an extensive experience with the legal and business affairs of complex mission-driven organizations. So we are in for a treat today. This conversation is all about building and protecting your brand. It's one thing to create your fashion line, create the name and all of this, but are you legally protected in the right way? If you put yourself out there in the internet and then someone grabs it and copies it and do what they do, you really can't go after them and say cease and desist now, can you, if you've never protected it in the first place? So Bill is here to just give some good steps along the way about how to legally protect your brand. And then also at the same time, too, if you're debating on, as a solo entrepreneur, should I be an LLC? Should I be incorporated? He's going to tackle all these questions for you today. So without further ado, I will hand it over to Bill. Bill, it is all you.
Thank you, my friend, and hello, everybody. I'm sorry I missed yesterday's show. I think it's what happened as you get older. Sometimes the technology gets over your head. I'm looking forward to talking to you today about protecting all of your assets, your brand included, but your designs, your clothing, how to protect those things. And we can certainly talk as well about whether you need a business entity. Let me try to pull up my presentation here. Goal today is to help you understand how to protect all of aspects of your business that relate to intellectual property, which is the overarching term for this, and then to talk to you about some protection related to entity formation. I've put some links in here to various places, but I want to tell all of you that are either in business or thinking about going into business, I want to encourage you to think about using SCORE as a business partner for you. We are a national organization. We're free. There are no ever any strings attached. We're confidential. If you want to talk about your business, we don't share that information. There are 80 counselors in the Boston area, some of whom have owned their own apparel businesses, some of whom have started branding and marketing operations, lifestyle branding, and so on. So we've got a lot of support in Boston to help you, but we're also connected with every other mentor in the country. So we can access you to people that are doing things if you're importing clothing or exporting or importing materials or have design ideas or marketing ideas, whatever. Please use us. We're here for you. We just can't wait to help you. And down at the bottom, you'll see some thoughts about how you can reach us. You can always leave us a message at the phone number there, 617-565-5591, or go to that URL and you can book yourself. You can search for the kind of advice that you need and then find people who have expertise and book a time that's convenient to you. So again, I know that there's great service. I'm familiar with the mayor's small business office. They do a lot of great stuff that's complementary to ours as well. So please use these services to the extent that you have time. We also do, as the mayor's office does, we have a lot of thoughts about how to access funding and how to put your business plan together to make a credible case for funding. So again, don't hesitate to let us help you. So if you think about your business, there's a lot of assets in it. There maybe is cash flow, accounts receivable, there's your employees, and all those things are assets to think about. But today we want to think about something that's pretty specifically of interest, I think, to people in the fashion and design world, and that's intellectual property. And it's, as the name suggests, it's a form of property. It's like real estate. It's like your personal property. Your inventory is personal property, the things that you own in your home. And like all forms of property, the U.S. has a system that allows you to have certain rights, and there are systems in place that we'll talk about to register some of those rights. So the definition is good for you to think about: creations of the intellect, such as inventions, artistic work, which a lot of fashion work is, designs and symbols, which is where Althea was talking about trademarks and protecting your brand. That's where that is going to come in. And the purpose of our intellectual property law is to protect your creations and your developments so that you can commercialize them. And the idea is that if we create a system where people can't steal your ideas or steal your intellectual property, then you're going to be more likely to get that out there into commerce and to share it with people, either in a for-profit or nonprofit way, and try to make some money out of it, be successful, and have the impact that you're hoping to have. So the legal protections for our IP come from several sources. One is patents, which we'll talk about, and those are a formal process to protect certain designs and things that have been created to manufacture or create something. Copyright, which is things that are written, things that are drawn, music is susceptible to copyright, web pages. Trademarks, again, that Althea talked about, is how you protect your brand, or kind of the subset of a trademark, which is a service mark if you're providing a service. For example, if you're a consultant or a lawyer or something like that. And then the last thing we'll talk about is something that's often overlooked with creative people. You don't get into your business in order to do contracts necessarily, but there are things you can do to understand when people are working for you, or you're working for other people, or you're acquiring products to refine or sell, or selling things to your customers, where the terms of the contract are important to have in place. So let's start with patents. This is probably in some respects, the hardest one, but there are two types of patents. One is a utility patent, and you don't see a lot of these in the clothing and apparel space, although now with people creating what's, better than me, is smart apparel or smart clothing, where there's some internet functioning or other functioning put in, you are seeing utility patents. But the other one is a design patent, and sometimes, although it's not easy to get a patent for clothing, and it can be expensive, and we'll talk about that. There are things that have received patents: the Crocs shoes, the messenger bag. The U.S. Marine Corps actually has patented some of its camouflage as a way to do that. So patents, if you get one, can protect your work for a very long time, 20 years for a utility and 14 years for a design patent, which is a good long time. It protects your rights within the United States and its related possessions. And this is key, the next point here, that your rights as a patent holder are the right to exclude others from making or selling your invention. But what is not excluded is, and this is where it gets weird, is the right to use, offer, sale, or import these things if someone else has a similar patent. And I'm going to talk to you a little bit, if you decide to go down this path, about what you need to do. So some practical things to think about here is that there are millions of patents out there that have no value. I don't know if you ever see on TV, sometimes George Foreman pitches this patent company, and he shows the little water playground that they have for kids. Well, it turns out that that person spent $25,000 on that patent, and it has never made them any money. So even though it looks cool and you can get a patent, doesn't mean you're going to make any money on it. So you always want to be thinking about, is this something that I need to protect in this way? The costs can easily reach $10,000 to $15,000 for the patent. So again, is your business idea worth it? And I'll tell you a brief story. I had a client come in who had one of these weighted blankets that she had developed to help children with autism who often find it soothing to have the extra weight. And she had spent $20,000 trying to pursue a patent to protect it. And she wanted to sell the weighted blanket for, like $1,000. So I said, why don't we go on the internet, because my daughter has autism, so I am familiar with these. And I said, why don't we go see what's out in the market? And there were very similar blankets, including the one we had bought, for about $100. So even if she had gotten her patent and spent $20,000 to get it, there was no way she had a market to sell that thing for that price. So you always want to be thinking about patent. You have something that you really think is patentable and it's going to protect a very meaningful asset in the context of what you think the market is and the business plan is for your clothing. If you decide you want to pursue one, and again, this is just to give you an overview, you want to contact us, you can always contact me. My email is on here, and we can get you in touch with some experts who can help you think about whether a patent is the way to go. Pardon me, just the other thing that I want to tell you about, when I told you that the rights of the patent holder are limited, if you do decide to pursue a patent with a patent attorney, you want to ask them for what's known as a freedom to operate. And that's an analysis by a patent attorney that says your patent, if issued, you'll be able to commercialize that the way that you hope to commercialize it. So it's an extra step, it's an extra expense that you need to take. So again, in most cases, a patent, we're just going to dispose of this pretty quickly, is not the best way for you to protect your assets, and we're going to talk about some other ways in terms of contract and so on. So in terms of a practice tip down at the bottom, it just may be better to conduct business with your partners by thinking of it as a trade secret and protecting it when you're in negotiations or when you're selling or licensing your product through a non-disclosure agreement. Now, obviously, if you're selling to your end user, your customer, and she's putting on the outfit or he's putting on the outfit, you're not going to have something like this, but they're not going to typically run off and try to commercialize that out from under you. So if you do have something that's unique and proprietary, you may be using special fabrics. I remember hearing an interview not long ago with the woman who developed Spanx, and she went through a year and a half of trying to find a material manufacturer that she thought would do the work the way that she hoped it would work, and couldn't find one. So actually went to a company and designed with them a proprietary material that she uses in her Spanx that had some qualities that the things that were otherwise available. So that's a trade secret. So if you've got a special way of connecting your clothes, again, if there's some functionality in the clothing in different ways, you might think of protecting that as keeping those processes, those formulas, the way you put the materials together, as trade secrets, and protecting them, as we'll talk about down the road, in the context of your contract with whoever you are working with. So it's really, the game for us really is played in the context of copyright protection, and then we'll talk about trademark. So anytime you draw a work, anytime you create a design pattern for something, I have a lot of clients who do design work where they'll sell it to wallpaper manufacturers or apparel manufacturers. So anytime you make a drawing, that's your work, if it's original, which it would be, and then you can copyright that. And it's a good thing for you to do, to be starting to put, if you don't already, when you're sharing drawings, or if you have a portfolio that you share with potential customers, is to put a copyright notice on there. And because that copyright notice gives you the exclusive right to reproduce that work and to make what are called derivative works, which are variations on the work that you might make. You may change color, add to the design, or so on. So the copyright does not protect an idea. So if you're talking with your friends about something, that's not copyrighted. It has to be fixed, as the language goes, in a tangible medium of expression. So that can be the drawing, it can be a written description of the materials that you're going to use. It could be a work. Again, you're all in the apparel and fashion industry, but if you're writing a play, you copyright that play, and so on. So again, unlike a patent, which must be registered in the patent office, you own the copyright when you create the work. And if you go to the Library of Congress, you can see how to put the copyright notice on there. And obviously, if you have any questions, you can reach out to me as well. But it's typically just the little C in the circle and then the date. And if you're sharing these without the date you created the work, and then you should typically say, you could list your name or whoever owns the work, and then you can use the words "all rights reserved," which means you're telling the world that they can't copyright this, that it's yours, it's not theirs, and so on. So again, the copyright protects a lot of different original works of authorship. In this case, it could be drawings, could be patterns that you have, and so on. It does not protect a specific item of clothing. So you can't copyright or patent unless you meet those few exceptions we talked about. You can't copyright a dress. That's why everybody can copy the Dior little black dress or something very similar to it, because they can't own that. So copyrights last a long time, 70 years plus your life if you're the creator. And if you have a corporate entity, it's 120 years. So way much longer than we have to think about here. So the big question, and I'm just going through this and then we can field if you have questions. The big question is, do I need to register with the Copyright Office? And the answer is no. You don't have to put any money into copywriting your works, but there's some trade-offs. So the work can be registered if you go to the link you can see there in the third bullet. And it's pretty cheap. It's about 8 to 12 screens of information, and then the fees are relatively low per design or per drawing if you're protecting things like that. And what it gives you is the ability to, if somebody is infringing on your copyright, which means using it without your permission and they won't stop, you can take them to federal court and seek to enforce those claims of infringement. And it used to be that you could at least try to stop the infringement without registering the copyright, but that has changed. So now you don't have any legal redress to protect your copyrighted work unless you have registered it. So again, if you have questions, if you need some help doing that, you can certainly go to the website that it's on, I think, the previous page. Oh, there, it's in the third bullet, excuse me. But we're here to help. There's amazing materials there about how to copyright your work. I know a lot of people that have done it themselves, but again, SCORE is here to help if you need help with that. So here's the kind of other side of infringement, if you will, which is a doctrine called fair use. And this is, can I use somebody else's work, or can somebody use my work without infringing? And this is something you need to be careful in. There's a lot of designs and a lot of patterns out there, and obviously there's only so many ways you can draw something, but fair use is very limited. and it is almost never appropriate in a commercial context. So if somebody picks up a piece of a design that you've drawn, or even something that is copyrightable or that you've copyrighted, and are using that and they're selling it in a way, obviously, if it's affecting your market, then that's clearly outside the scope of the fair use. So what do I do in that situation, you might ask? Well, one thing that you might do is, and again, we can help you here, is write what's called a cease and desist letter. If someone is uh, infringing on your work that you've copyrighted, that you've created, the first step you want to do is tell them that you think they've violated that work, they're violating your copyright, and then ask them to stop. And if they don't, and if you've registered the work, then you can think about how big an impact it's having and whether it makes sense for you to pursue that as a legal matter to stop the infringement. So here's the other piece that we need to, I think about in some detail, which is what happens when you do a design for someone else or you hire someone to do work for you. And this is an important doctrine, particularly in copyright law and also in patent, but it's more applicable, I think, for us. And the related doctrine, there's the doctrine of work for hire, which we'll talk about. And the other one that we often see is joint authorship, which is where we have two people who are friends, or they start a business and they're working together and they're both working on the design or something that's copyrightable. So first, let's touch on work for hire. If you are hired by somebody, either as an employee or an independent contractor, to create something that's copyrightable for them, the presumption is that they own the work and that you're doing what's called work for hire. So what does that mean for you? It means if you don't want to give them the work, or if you're incorporating work that you've already created into the deliverable or the product that you're going to give to the employer or the person who's hired you, then you need to carve out some rights there, and you need to say, I'm going to give you the use of this product for the purpose that you hired me to create it for, but I'm not going to give you all the rights, and I'm going to retain all those other rights. And the point here is that if you're a creator of intellectual property here, a designer, this is your stock and trade, and we need to be thoughtful and careful about not inadvertently handing that over to someone just because they hired you to do some design work for them or what have you. Whoop, I'm sorry. Excuse me. All right, so the next piece, as I talked about, is joint authorship, and it's more common than you might think. The two people start out pretty excited about working together and creating a business. Everybody's doing everything and they're designing stuff together. They're creating this intellectual property, but their vision for the company, their interest in pursuing it changes, and one of them wants to get out. So in that situation, the two or however many people that created that work are joint authors. And joint authors means that each of you who helped in the creation of the work own all of it and can use it independently of the other person. So if you and I created a work and I want to go one way with it and you want to go another, you can't stop me and I can't stop you unless you have a written agreement that specifies what the rules are between you. And if I go my way and I take and commercialize the product my way, the one thing that I have to do is to share with you any profits that I make from that, because you own it as well. So that's the final bullet there, that the joint author must account to the other joint authors for profits received. So you need to be careful when you're in these particularly early stages, when the excitement is about the product and everything, that you're thinking about who owns what and you're starting to formalize some of that in some written agreements that, again, people at SCORE can help you with. So some copyright resources here for you. Again, I don't need to read these to you, but there's some great information at the copyright.gov office, a ton of good FAQs, good information. There are professional organizations. I've seen several in the fashion industry that have very good information about protecting your works through patent and through copyright. So use those. Again, use us to the extent we can be helpful to you. And now to the last of these, before we have a little discussion maybe about creating a business entity, is how do I protect my brand? And the two ways that we do that are trademarks and service marks. So a trademark, again, you're familiar with these. It's a word. Althea has some great trademarkable symbols and logos and words on her site. I don't remember if she has the TM on there, but hopefully we'll get it on there. And so it's things that identify the goods or services that you're delivering. If you are selling clothing, think of that little guy on the polo horse there. That's a trademark of Ralph Lauren. So a service mark is just like a trademark, only it's in the service industry. So they're indistinguishable, except for whether you're marking or branding a good or marking or branding a service. So trademarks, like copyright, belong to you when you create them. As long as they're original, they're yours. And you should, again, get in the habit of putting the TM for trademark or SM on your things when you're sharing them with other people. It's not an issue. It's easy to do. If you elect to register a trademark, which we can talk about a little bit, then you can put the circle and the R, and that tells people, like with the copyright, that you've taken the extra step to register it, which means the trademark office has said you're not using a trademark that lands on any other space. So that's a federal process to register the trademark. And you can also, if you think your market is going to stay in Massachusetts, there's also a Massachusetts trademark and service mark. So you can see the link down here to access that, the Massachusetts trademark and service mark. And you can see some basic facts about those there. But again, they're clear, they're well written. But if you feel like you have questions about any of this, or is it worth it to go through the expense of filing for it, let us know, because we're here for that. So a few more thoughts about not only protecting your brand, but commercializing it, getting it out to the people, having the impact that you want. And so remember that your intellectual property is just like any other kind of property. You can protect it. You can put your name on it, just like you can put your deed on a house or the license on your car or what have you. So the question that sometimes come up, or a few questions that we have in this context, are, do you want to be in the business of designing something? Do you want to be in the business of designing it, manufacturing, designing, manufacturing, and selling? So if you think of the links in the supply chain from creation to the last mile delivery to the customer, you need to think about what roles you want to play and you can play. Because sometimes it's better to think about finding an existing distribution channel, a store, an online retailer, whatever, and not trying to replicate that process yourself, which is time consuming and has additional risk. So again, we can talk about that in more detail, but just think about every step in the chain and where you see yourself in it as you're creating your fashion and your apparel. So the next thing I'll talk about briefly is compensation. Runs a gamut. On the one hand, you can get paid a price for your product from your customer and you move on down the road. If you're licensing your work to a bigger distributor, they can either pay you outright, or they can give you what's known as a royalty, where as they sell more product, you have a percentage and you get more in return. And then you can have hybrids of those where you have some money up front and some royalties dependent on sales and so on. So I'm assuming we're not doing anything with software or algorithms. So I'm not going to really deal with that. And just let me talk about this briefly. I'm not sure how much time we have here, but the non-disclosure and confidentiality agreements, if you're talking to people about licensing your work or licensing something where you have a proprietary idea, or obviously if you're showing them patterns or designs, you want to make sure your copyright is on there. You want to think about a non-disclosure agreement where you're making sure that they're not going to run off with your work. The concern there is oftentimes when you're talking to bigger companies that you want to try to protect the work that you have. I'm not going to talk a lot about insurance or indemnification. That's probably more than we need to get into now. But if you are in the business of manufacturing your apparel and you're the one who's selling it to the customer, you need to think about insurance to make sure that the apparel is safe for the intended use. If it needs to be non-flammable, if it's for children, and so on. So you need to think about those kinds of issues. And again, if you're in that space and thinking about your role in that piece, give us a call and we can get that in more detail. I'm going to skip this because I think it's not really what Althea wanted me to talk to you about. Again, if you're here, if you're thinking about contracts, we can help you think about those. And in the couple minutes I've got left, what I'd like to talk to you about is business entities. And I don't have slides for that, but I'll send some stuff to Althea to share with you. But basically, when you're working by yourself, you're a sole proprietor. And that means you pay your taxes when your money comes in, but it also means that you are liable for any injuries or claims made against the product or the business that you did. If you don't pay a supplier or what have you, you are personally liable for that. So your personal assets are at risk. So a lot of people think that when they get a DBA, a doing business as, and so on, they've created a corporate entity, but that's not the case. So if you have a DBA, you haven't changed your liability in any way from just being a sole proprietor. So the simplest way to create a barrier against personal liability is to form what's called a limited liability company. Now, if you're all in Massachusetts, I'll send this link to Althea too, but it's a very simple process. The only downside to it is it costs $500 a year to first register and then maintain the license. But if you are in business, if your sales warrant this expense, it's a good thing to put into place, because then your liability is limited to the liability of the company as opposed to your personal assets. So I think I will stop there. I'm going to see if I can close this screen and see if there have been any questions.
So I'm back in the equation here. This is a wonderful presentation here, Bill. Okay. Have some questions actually did come in. So first question we have are, what are the cons of having an LLC, and what should people be aware of when starting an LLC?
So there are no real cons other than the price. And if you're a small business and you're, trying to grow, I often tell people, if your sales aren't that big, put that money into marketing or growing your business first, because your risks are pretty low. But if you've got enough revenues to, justify the $500 fee, and it'll take you less than an hour to create it yourself, there's really no downside to doing it, and it gives you that extra layer of liability. Just like insurance, if you are at a point where you have sales, you want to get some insurance out there just to make sure that if product liability is an issue and so on. So those are the only cons that I can think of. And again, the upsides are that they protect your personal assets from risk.
Okay, and then you were mentioning for Massachusetts. So what if you move out of state? Do you have to like look at those states' laws? Okay.
Yeah, so if you're doing business in Massachusetts, you'll set up here. If you are from another state and doing business there and come here to sell and start doing business here too, you would set up the LLC in your home state, and then you would register here as what's called a foreign corporation.
Okay.
So there are a lot of businesses that are in Delaware, for example, but they do business here. So they're registered here in both states.
Gotcha. And then how long does it take to get a trademark?
Online, it depends. I think it can take a couple of weeks and maybe a little longer. If it goes right through, it'll go through quickly. But if an examiner has some questions, the trademarks are a little different, and I could have bored in a little deeper here, I suppose, in that trademarks are issued in kind of classifications. So like there's a trademark in apparel, and then there's another trademark in software or educational services or, boilers and mechanical equipment. So when you apply for a trademark, you're applying for it in a specific area like apparel or clothing.
Okay.
And what the examiner does is look through and sees if your trademark is close enough to any others and so on. And if they don't, then you go right through.
Okay.
And you can check online if you have a particular trademark at the link that I put above for the trademark office, and actually check and see if the names that you want to use are in use.
Oh, okay. And then for our final question that we have, it also pertains to the trademarks as well. Is it best do you need an attorney to help register your trademark, or can you do it on your own? Because you see those sites like LegalZoom and stuff like that. Is it easy enough to do it, or is it wise to go through an attorney to do the trademarking?
I think if you have a simple trademark, I know a lot of people that have come through SCORE that have done them on their own. So I'll start with that. If you get hung up, if you start getting a lot of questions from the examiner, it can get tricky. I think LegalZoom and those places are probably as cheap as they're going to get, but my worry is that they're cheap because they can only do the simple ones that you could do on your own. So, I always feel like small businesses, money is tight. So, and we can't do it for you, but we can help you navigate it. So, give us a try if you're wanting to do that. And if we can't help, we'll be the first to tell you this is probably one where you need to get outside help.
Gotcha. Wonderful. So, Bill, thank you so much. This was a great conversation, or a great presentation you actually gave. And I hope that our attendees have gained some wonderful insight about this and the next steps. And also, again, use SCORE Boston. SCORE Boston is here. If you're tuning outside of the Massachusetts area, just look into your city to see if SCORE Boston or if SCORE is in your city, because they are in various parts of
We are all over. Any city in the country has a SCORE office.
So there you have it. There's your major gem of the day, that SCORE is all over the U.S. So if you're not inside of Massachusetts or in Boston, at least you can definitely look up and Google SCORE to find in your city and state and go from there. Bill, thank you once again for this opportunity to give this amazing presentation. And I want to thank everyone for tuning in for building and protecting your brand.
Thank you very much. Have a great day.